Good evening and welcome to The Story. I'm Evan Watson in for Pat Doris tonight. Earlier this week, we told you the U.S. Supreme Court decision on a homelessness case out of Oregon was imminent. True to our word, it was released this morning. There are few, if any, immediate impacts here at home, but the long-term implications could reshape homeless policy for years to come. It's our big story tonight. The U.S. Supreme Court has sided with Grants Pass, Oregon, ruling that regulations and penalties around homeless camping do not constitute cruel and unusual punishment. The decision will likely have major implications on how cities make and enforce public camping rules. This case is the most significant to come before the Supreme Court in decades on the issue of homelessness. And it comes as cities in the West like Portland, Seattle, and San Francisco have struggled to manage tents and outdoor encampments. Kyla Boshi breaks down what the ruling means.
A landmark decision from the U.S. Supreme Court on the issue of homelessness. In a 6-3 vote, the High Court cleared the way for cities to enforce bans on homeless people sleeping outdoors when there's no shelter space. The case centered around Grants Pass, where Helen Cruz was once homeless.
Just because we don't have a home, we don't have a white picket fence, doesn't mean that we don't deserve the same respect and dignity as everybody else.
The Southern Oregon city tried to block people from sleeping and camping in public spaces, including sidewalks, streets, and city parks. On Friday, the High Court found those rules did not violate constitutional protections against cruel and unusual punishment.
Right now, this whole community, the homeless community, is in fear right now of that they're going to start being arrested and going to jail.
The decision is likely to alter how cities and states throughout the West handle homelessness. Officials across the political spectrum had filed briefs in the case, saying lower court rulings out of the Ninth Circuit and another case in Boise hamstrung their ability to clear encampments and manage a visible and growing crisis. Aaron Heisel is one of the attorneys representing Grants Pass.
I think that giving the local leaders for their communities the options of knowing what's best for their community and those experiencing homelessness in their community is going to save lives. They're going to know what they can and can't do with their resources instead of being forced to spend it on shelter space that may not go utilized.
Homeless advocates complain local ordinances, similar to the laws enacted in Grants Pass, essentially criminalize homelessness. Ed Johnson of the Oregon Law Center and lead counsel for the homeless plaintiffs says there's a separate important issue to be addressed.
We don't have enough housing, and lawyers and judges are not going to fix that problem. The police are not going to fix that problem.
Nothing in Friday's ruling requires cities to take stronger action against homeless people, but it could alter how they police homelessness.
Let's bring in Kyla Boshi now. So where do we go from here, Kyle? Is this legal fight over?
No, far from it, according to homeless advocates. They're going to continue to challenge policies that punish the homeless, and the legal fight will continue, they say, on every level. You heard briefly from Ed Johnson. He's with the Oregon Law Center and was lead counsel on the Grants Pass case, representing those homeless plaintiffs. As he explains, the Supreme Court made one important but narrow ruling that cruel and unusual punishment doesn't apply to this case.
We have an excessive fines claim in this case. We have a due process claim in this case. And more broadly, the legal fight is going to continue on every level. There are still affirmative federal constitutional rights that can protect people who are living outside. There are state constitutional rights that can protect people who are living outside. There are state statutes like the one in Oregon, and even the majority of the Supreme Court today recognize that people can bring a necessity defense if they are charged with a crime. And to me, that's a no-brainer. We know it's necessary for people to use a blanket so that they can stay warm and dry and not die of hypothermia. So that defense is going to be more important than ever.
So still a long way to go with different angles. Kyle, thank you. Leaders in Oregon we've spoken to over the past few weeks say they don't expect to see immediate change in Oregon in the wake of this decision. It'll likely be a while before we see how it really plays out, and that is because of Oregon's House Bill 3115. Lawmakers passed that bill 3 years ago with the goal of codifying the Ninth Circuit's Martin v. Boise ruling, the one the Supreme Court just overturned. Cities and towns were ordered to draw up laws around homelessness that the state calls objectively reasonable, when it comes to time, place, and manner restrictions for people who are homeless. House Bill 3115 is still the law of the land in Oregon. The Supreme Court ruling does not affect that at all. The local ordinances that were put in place because of it also stand, like Portland's watered-down camping ban, which will begin to be enforced Monday. That's why we won't see big changes here in the short term. But when Pat Doris sat down with Portland Mayor Ted Wheeler earlier this week, the mayor said cities need clarity from the state on what objectively reasonable means when it comes to homeless policy.
Okay, and I'm always confused when I hear this reasonable time, place, manner. What is that?
It is confusing,
yeah.
And I'm glad you said that because to comply with that state law, the city of Portland passed an ordinance that we thought was very moderate in terms of time, place, and manner restrictions. We believed we'd met what is called the reasonable standard that is required under House Bill 3115, but a Multnomah County judge enjoined us, meaning she decided that we had not met the threshold for reasonable time, place, and manner restrictions. So that basically put it on hold.
Okay, but what does that mean? Reasonable time, place, and manner?
We don't know.
Well,
and so here's the problem.
Okay, but
the term reasonable
yeah.
hasn't been defined by the legislature. And that is one thing that I would request that they do. If they want to keep some time, place, and manner restrictions in place, they have to define reasonable because the court refused to do it. We thought we defined reasonable. The court refused, said that we had not done so.
There are also others like City Commissioner Renee Gonzalez who see House Bill 3115 as a mistake and something that the legislature needs to address in 2025.
They either need to repeal it or fix it. It was based on a really faulty foundation. They essentially tried to codify Grants Pass and Martin. I think that was a mistake. The Ninth Circuit was always an outlier here. And it's really interfered with cities' ability to address the challenges on our streets.
We reached out to Governor Tina Kotek today. When House Bill 3115 passed back in 2021, she was the Speaker of the House and the chief sponsor of the bill. We wanted to know if she'll be asking lawmakers to make any changes to that law. Her office sent us a statement pretty much dodging the question, saying the intent behind House Bill 3115 was to affirm that cities choosing to regulate survival activities like sitting, lying, sleeping, or keeping warm and dry must develop laws that are reasonable and take into account the resources available to individuals experiencing homelessness. There are many communities across Oregon that have appropriately responded. She went on. Regardless of the court's decision, we must do all we can to address homelessness. This includes addressing the primary driver of homelessness, our lack of affordable housing. Even if Governor Kotek is non-committal on that, there are state lawmakers who are already thinking about House Bill 3115 and its broad interpretations. I talked with Senate Republican leader Daniel Bonham. He says the legislature needs to act to make it clear for the cities what exactly is reasonable when it comes to homeless camping policy.
I do think, pragmatism should rule, and we as a legislature should come together to give the local jurisdictions the clarity that they really need to move forward.
Bonham says 3115 harms local government's ability to address homelessness in a compassionate and effective way. It's early, so Bonham admits he's not sure if lawmakers will propose an amendment or try to repeal and replace the bill or something else, but he believes there's a need for clarity on this topic if everything rests on one bill.
I have not had a chance to talk to Democrat leaders yet as to what their appetite is, but I do think it's fresh, it's hot. People are right now digging back into it to see which direction we need to go.
Democrats are a bit more cautious. Senator Case Jama couldn't talk with me on camera, but he said his office is reviewing the Supreme Court's decision and how it intersects with Oregon law, adding, I think it's too early to determine whether or not changes to House Bill 3115 are needed. In any case, we must continue balancing the rights of all people, regardless of their housing status, with the accessibility of public spaces. Jama says criminalizing homelessness is not an effective or compassionate policy tool, and like the governor, he also points to affordable housing production as the top priority, regardless of the legal interpretation on homeless camping bans. But we did hear from a Southern Oregon lawmaker as well who sponsored 3115, who told us she would need to be persuaded to change that law.
I think we came upon a pretty balanced policy in 3115. We said very clearly that cities can regulate the presence of homelessness on their streets. They can enact time, place, and manner restrictions. And we also said that those restrictions have to reach a reasonableness standard. So you can't put in restrictions that prohibit anybody from ever being on your streets if they have no place else to go. You have to make sure that you're accommodating the presence of homelessness in your community. So I think our goal there was to strike that balance, and I think we did so. So I would have to be persuaded that that needed to change.
In all of this, the Supreme Court's ruling doesn't just affect Oregon. It applies to western states in the Ninth Circuit, from Washington to Montana to California and beyond to Hawaii and Alaska. While Oregon has House Bill 3115s on the books, other nearby states don't. I talked with Becca Habiger, a reporter with our sister station in Sacramento, who's interviewing lawmakers there in California. She says local and statewide politicians in California are generally in favor of this Supreme Court decision and now feel they're able to pass new restrictions on homeless camping. As always, that comes with a balance of enforcement and compassion.
I think they're trying to tread that fine line, but now without the grants pass decision in their way, if you will, I think they'll feel more emboldened to pass and enact such ordinances and laws addressing homeless encampments in public spaces.
A bipartisan bill to restrict homeless camping in California didn't make it out of the most recent session, but the bill's sponsor said today that he'll try again next year given the Supreme Court's ruling. It's worth noting that even Democratic Governor Gavin Newsom of California wanted this Supreme Court ruling. In a statement, he said state and local officials no longer have their hands tied and they can now remove unsafe encampments from the streets. In the meantime, here at home, we're hearing from homeless advocates who work in Portland's Old Town neighborhood. They believe the Supreme Court decision will not have an immediate effect on their work, but will eventually harm those living on the streets.
We do see this as like the first chipping away at the rights that we've worked so hard for. Just to continually revert back to criminalization makes us really angry because we know it's going to cause so much harm and trauma, which will then further us from our goals of having people in safe, stable places to live.
And I can appreciate why people are angry. In fact, there's a lot of anger to go around in our community. And I think too often we talk about and we think about these issues in us and them or us versus them terms, as it's going to rely on what we do as a community to solve for those crises, not what 6 people decide in Washington, D.C.
So what do you think of the Supreme Court's ruling? Do you think it will help the homeless crisis by allowing cities to punish people camping on public property, regardless of shelter availability, or make things worse? Email the story at kgw.com or call and leave a voicemail 503-226-5090. And while we're on the topic of the Supreme Court, this morning justices also released a decision that weakens federal regulators, overturning a decades-old ruling that will likely have massive impacts on government regulation for things like the environment, public health, and consumer protections. 40 years ago, the court ruled that judges should play a limited, deferential role when evaluating actions of agency experts. To put it simply, federal agencies should be allowed to fill in details when laws are not crystal clear, and often laws don't cover everything. So the long-standing ruling let agency experts, think the FDA on food safety, decide what is best. Opponents argue that it gave too much power to these experts who work for the government and that judges should decide instead. Today, the court agreed with that position, delivering a potentially lucrative victory to business interests by weakening government regulatory powers. The Associated Press reports that billions of dollars could be at stake in challenges now spawned by this decision. There's a lot more here and a lot more to cover. We'll be watching. Up next on The Story, we're taking a break from the nation's highest court and heading out to Malheur County in eastern Oregon. Local newspapers are dying off across the country, but a paper Malheur is bucking the trend and gaining national recognition along the way. That's next when The Story returns. Here on The Story, we talk a lot about how smaller news organizations, especially local newspapers, have been dwindling in number year after year. It's no secret that rural areas have been hardest hit by those closures, often having to rely on outlets in larger cities that don't often cover those smaller communities. But there's one Eastern Oregon publication that's bucking that trend, and it's one we've featured here on the show before. Thomas Schultz has the story.
If you follow the Oregon Trail, you'll come across Vail, the first stop in Oregon settlers reached in 1811. And near the heart of downtown is the Malheur Enterprise, a county newspaper over a century old.
1931, I think we got some back to the 20s.
With archives
See how far back these go.
that stretch way back.
Obviously, getting to be 100 years old, that paper's pretty fragile. So
Fragile.
Yep.
Like the newspaper business.
What's the major story? A woman from Idaho disappeared north of Jordan Valley last summer.
Since 2005, the New York Times says a quarter of newspapers have closed nationwide. 2,500 overall. Closures are more common in high poverty areas.
Malheur County is one of the poorest counties in Oregon. Malheur County is literally in a different time zone from the rest of the state. I mean, we have a number of things going against us here in Malheur County and at the Malheur Enterprise.
Instead, it's a much different story.
We are interested in representing the average person in Malheur County. Yes.
Les Zeitz is the owner and editor. He took over the paper in 2015 and transformed operations.
We've used the Enterprise as a bit of a journalism laboratory.
By focusing on digital growth and tinkering with the paper's coverage of a county that's larger than 9 states, they also asked the questions others weren't.
We questioned budgets, we questioned decisions, we questioned policies.
They specialize in investigative reporting and ask for information government agencies aren't always thrilled to unveil.
A lot of public agencies here had never seen a public records request before the Enterprise turned around.
Readers noticed the change. Journalism institutes did too.
Yeah.
And the Enterprise has won
Scripps Howard.
Dozens of recent awards.
We've been awarded a number of other awards. In 2017, Investigative Reporters and Editors, a national association.
Many thanks to investigative pieces.
The first ever Freedom of Information Award to a weekly newspaper and gave it to the Malheur Enterprise.
And recently, they won a national award from the Poynter Institute, beating out the Washington Post for an investigation into a rail station project.
And the winner is the staff of the Malheur Enterprise of Vail, Oregon. The judges called this a fantastic example of a small paper doing big work to affect real change in the local community.
I mean, that's a pretty good day at the office.
The paper reported on the project for years.
Yeah.
Reporters found the project, meant to help farmers export their crops, was hindered by county money mismanagement and delays. Throughout the reporting, they fought county government secrecy and eventually sued to enforce state public records laws.
Ooh, yeah, it's kind of a big deal. It takes a big investment.
For 8 years, Pat Caldwell's reported for the Enterprise, spending much of that time digging into the rail station.
Yeah, God, now that I think about it, that's a long time.
When Caldwell joined the Enterprise, he was already a 15-year industry vet.
I didn't quite understand what I was getting into. I thought I was pretty good. Then I came here, and then under Lesson Scott, I learned that, no, I have a lot more to learn.
The story will pretty much write itself.
More to learn, under the tutelage of Zeitz, who was an investigative reporter for the Oregonian for 25 years. Though his time as a scribe dates back even further.
You know, my first published byline was when I was in the 6th grade, and I did a history piece for the Old Kaiser News.
And after more than 50 years in journalism,
I frankly feel, as sort of a senior journalist in Oregon, that I have a responsibility to help journalists and journalistic organizations restore the trust of Oregonians and the American people in the press.
And in Vail.
And this is a very, right-wing Republican area.
They've done that.
At a time when circulation is going down across the country, our circulation was going up.
They believe their success means other publications can make a comeback too.
And that's a huge statement. And yes, I get it. I understand it's a huge statement. And but we've backed it up.
To restore newspapers to small communities nationwide.
We shouldn't have succeeded. We should not have succeeded, but we did.
In Vail, Thomas Schultz, KGW News.
Thank you to Thomas for that reporting. Up next on the story, we turn our attention to the 2024 Olympics in Paris. The opening ceremony is less than a month away now, and some have wondered, are Team USA athletes paid to compete? We'll verify when the story returns. KGW is your home for the 2024 Paris Olympics, where hundreds of American athletes will compete in the Olympic and Paralympic Games. But are those athletes paid for winning a medal or for just participating after making Team USA? Brandon Lewis with our Verify team explains.
Athletes often say representing their country at the Olympics is the highlight of their careers. One Verify viewer texted us to ask, do athletes get paid to go to the Olympics? So, let's verify. Our sources are Team USA, USA Swimming, USA Wrestling, World Athletics, and the International Olympic Committee. The IOC doesn't pay athletes, nor does it require countries to pay athletes, but there are ways for the competitors to make money at the Olympics. This year, for the first time, gold medal winners in 48 track and field events will receive a $50,000 prize. The money is awarded by World Athletics, the international governing body for events like track and field and running. National Olympic committees and governing bodies may also give their athletes some money. The U.S. Olympic and Paralympic Committee gives American athletes a bonus of $37,500 for each gold medal they earn, $22,500 for silver, and $15,000 for bronze. Some sports governing bodies like USA Swimming use registration fees to give top-tier athletes a monthly stipend. USA Wrestling has a Living the Dream medal fund that awards a stipend of up to $250,000 to medal-winning wrestlers. Other sports get corporate sponsors and use the proceeds to cover some of an athlete's expenses. With your Verify, I'm Brandon Lewis.
Lucrative in more ways than one. Of course, a lot to watch this year at the Olympics. That is the end of our show tonight. Thanks for watching. Speaking of the Olympics, more track and field trials from Eugene are coming your way next, followed by the start of gymnastics trials later tonight. I'm sure many of you are looking forward to that. Hope you enjoy that coverage and have a great weekend. Pat will be back with you on Monday night at 6:30. Until then, have a great night and a great weekend.